Ms. Conley, can you start your video and unmute yourself, please? Calling the case number of SP4519123. This is the state of Michigan versus Mina Jenna Conley. Your appearance, please. That means tell me your name, ma'am.
Manaya Janae Conley.
Okay, and this is the date and time set for an informal hearing. It was set for 9:31. It's now 9:49. The officer has failed to appear. Therefore, this matter will be dismissed without prejudice. Any objection?
No.
Okay, but before that, ma'am, it's just not always going to be that easy, because I would like to note two things. You're driving at a disgusting rate in a construction zone.
Mm-hmm.
You are putting your life and that of construction workers in danger, driving your car in such a manner. Okay? When I read this remark that says you are going 81 in a construction zone, that sends me. Okay? There is no reason in life, and you are not that important, for you to be driving so recklessly and selfishly on the road. And then I look at the ticket, and the trooper gave you a deal and wrote you a ticket for 5 over, which was a gift, right?
Right.
Because 81 in a construction zone, certainly if I do the math, is not 5 miles over the speed limit. And instead of taking responsibility for that and taking the loss and taking the break from the officer, you requested an informal hearing on it. And the break for you today is the trooper did not appear, so the ticket will be dismissed. But all that shows me, the court, is the type of person and driver you are. That you would drive in a construction zone where there are workers. Don't roll your eyes at me. Don't roll your eyes at me. And get a break at the road from the trooper. And instead of being gracious and responsible, you pushed for even more consideration. And you get that break today on a technicality because the trooper didn't appear. But you better think long and hard about yourself. If you roll your eyes again, I'm going to set this for another hearing.
I'm looking up. I'm looking in the background, never roll my
Okay,
eyes.
well, I would like you to look at me. There's no reason to be looking up.
Okay.
Show some respect and stop being such a selfish driver. And if you can't handle the responsibility of driving and the workers on the road, do everyone a favor and hang up the keys. Those men and women working out there are risking their lives. And the fact that you got such a break on the road and pushed it for a hearing today shows me that you think there are no consequences to your actions and you should just be excused for your selfish behavior. Learn that you exist with other people in this community and you are not important. You are not important enough to be driving and disregarding the other people and workers on the road. It is not about you. Slow down, be aware, and if you cannot be responsible enough, then don't drive, because it's a privilege. Are we clear?
Yes.
Okay, you may leave the Zoom.
With that situation resolved, the focus now shifts to Michigan, where defendant is dealing with a bond violation along with a new felony charge. The court initially granted bond on the new case and offered an opportunity to remain compliant. Shortly after that, the defendant made choices that raised concern in the courtroom.
Thank you and welcome back. So we're going to begin in case number 25-4703 FY Mr. Ullman is appearing for arraignment in the underlying charges. He had one failure to appear, but we had renoticed that, so he's not facing any issues with regard to a failure to appear for the arraignment in this case, just the bond violation issues.
Okay.
And arraignment in the underlying charges. So Ms. Ferrara-Wilbur, did you have opportunity to review the allegations on the felony complaint, nature of the offense, possible maximum penalties, as well as the issues with regard to the bond violations with Mr. Ullman?
Yes, thank you, Magistrate. We did have the opportunity to review the complaint and the alleged bond violations, as well as Mr. Ulam's rights in this matter. In regards to the underlying charges, Mr. Ulam waives a formal reading, pleads not guilty, and requests court-appointed counsel. In regards to the bond violation, he also waives a formal reading, pleads not guilty, and requests that it's set for a hearing with counsel.
So I will appoint an attorney for you. I'm going to remind you that you have the right to remain silent. Anything that you say orally or in writing can be used against you. You have the right to have an attorney present during any questioning, and if you could not afford an attorney, the court would appoint one at public expense. You have the right to have the attorney present during all subsequent court proceedings. Ms. Ferrara-Wilbur, is there information you'd like me to know regarding bond?
Yes, thank you, Magistrate. In this matter, we would request that the bond is reinstated. On May 28th, it was set at $25,000, 10%. As Mr. Ulam stated, he does part-time handyman work. He's currently homeless and has no access to funds for a bond, but he has taken steps to obtain a mailing address and has access to a phone to maintain contact with the court and counsel in this matter. Thank you.
Well, at one point, he had posted the bond through bonding agency. So he had been out, and thus the reason for the allegations on the bond violation. And with regard to that, Mr. Ulam, I am going to remand you to jail until the time of that hearing. So the bond that you did have is gone. You are no longer on bond. You'll be remanded again until the time of the hearing. We'll get that scheduled as quickly as possible. You should hear from your court-appointed attorney by the end of next week, and we'll make sure that the hearing is expedited.
Because of the bond violation, he lost a 10% bond set at $25,000, which equals $2,500 after picking up a new felony charge. As a result, he will now remain in custody without bond until his next court appearance. The court must next determine the bond amount for the new charges alone. That decision will be based on risk behavior and recent actions. What happens next will show how the...
We'll move on to case number 25-4779SM. And Ms. Ferrara-Wilbur, you had opportunity to review the allegations in this complaint, nature of the offense, and possible maximum penalties with Mr. Ulam as well.
Yes, that's correct. We did have the opportunity to review the complaint as well as his rights in this matter. At this time, Mr. Ulam waives a formal reading, pleads not guilty, and requests court-appointed counsel.
Based on the information that you've provided, I will appoint an attorney for you in this case as well. The next step in the process is a pre-trial conference. In this case, the pre-trial conference would be scheduled for July 15th. It would be at 9:30 a.m. And again, Ms. Ferrara-Wilbur, information regarding bond.
Thank you, Magistrate. Based on the remand in the other matter, we would request a low cash bond in this matter.
So your bond in this case is going to be a $10,000, 10% bond. Conditions on this bond are that you may not use nor possess any alcohol, any illegal substance, any controlled substance, including marijuana, any mind or mood altering substances, or any non-prescribed medication. You'll provide a list of your current prescriptions to the district court clerk. You will submit to discretionary PBTs and discretionary urine screens whenever requested by a police officer or any court personnel, so you may not refuse. You would have an immediate urine screen and twice, we'll say 8 times per month, urine screens hereafter. You'll have no contact in any manner whatsoever with Darcy. Means no phone calls, no messages through other people, no mail. You may not text message nor through any social network have any contact with her. You will stay 500 yards or more away from her. You may not be at any address that she is or may be. Specifically, you may not return to 811 Linwood Lane. You may not use nor possess any.
No,
Excuse
Mr.
me,
Ulam. No,
what
Mr.
address?
Ulam. No,
What address?
Mr.
What address
Ulam.
again? What address? I'm just confused. I just wanted to repeat when I want to understand what the address was. What was the address?
The allegations in this complaint allege that it was at the residence at 811 Linwood Lane, but you
Okay,
can't
okay.
be at any address that Darcy Robinson is or may be. You may not be within 500 yards of her
I get it.
workplace or any
I understand. No,
address.
I get it. I get it. I just want to clarify that I can't go to my home. I can't go to my house. I get it.
Mr. Ulam.
I'm homeless and I can't go to my house. Thank you. That's good. Thank you. Just making it clear that I'm not allowed to go to my home. Thank you very much.
You may not use or possess any weapons of any sort. You'll have no threatening, intimidating.
I know what the last ones were. Thanks a lot. What are you talking about? You took away from my phone. Hey, tell Darcy Robinson not to bomb me out again too. She bombed me out last time. Tell her not to bomb me out. Hey, come on.
So the words that I'm speaking about the no contact are in effect immediately, Mr. Olam, and it's going to be a $25,000, 10%.
He originally had a $10,000 bond set at 10%, but that amount was quickly increased to $25,000 at 10% after his behavior escalated in court. That reaction directly affected how the judge assessed risk and responsibility. We now move to the third and final hearing of the day. This case involves a self-described sovereign citizen who believes he can live without paying rent for 18 months.
All right, parties. I'm gonna figure out, and then we'll determine whether or not how we're gonna proceed. How we're gonna continue on. So I need both of you to unmute for me.
Yes, sir.
All right. Both of you raise your right hand for me. You swear or affirm to tell the truth under penalty and perjury of the law?
I do.
I do.
So let me first get a little bit of basic information. So Trust Property Services, do you guys have is this a commercial or residential?
This is a residential property.
All right, great. And when was the lease entered into?
March 25th, 2019.
Okay, when was it last renewed?
It was renewed on, it was signed on March the 9th, 2022.
Okay, and has it just been renewing every month since then?
Yes,
I mean,
sir.
every year. I know, but...
Yeah. Every,
Okay. All right. And so, technically renewed again on March 2025, but I understand that there's allegations of default before then. So, how much is monthly rent?
$1,750.
Okay. Is there a late fee? If so, how much?
There is a late fee, Your Honor. The lost discount is $100, and then there is a $10 per day additional rent, but I understand you have it capped at 10%.
Yeah, so we can do it at 175, which would be the most. When's the last time the tenant paid rent? How many source?
That was on the ledger there. It was February 25th, 2022.
That's the last time you paid any rent?
Excuse me. No, sorry. That was when he started paying rent again. So previously he got behind significantly, and the county stepped in and
Objection, Your Honor.
Oh, okay, well, he can tell me what he wants to say. Overrule. Continue.
Okay.
Okay.
And March 25th, 2023 was the last time rent was paid. So we began accruing rent at April 25th, 2023.
Okay, well, your complaint doesn't ask for all of that. It says that it is from December 25th, 2024 through March 2025. So explain that to me.
I did not file it myself. My assistant has been in the hospital 4 times, and some weeks at a time. So I'm not sure what was filed.
Well, that's a concern because you're pursuing this. I've got that this was filed back on, this was filed April 8th or April 18th. So this is well after that. well for an opportunity for you guys to make any additional determinations. I just want to make sure we have some clear numbers, because the numbers that you're asking for in the complaint that was past due in April of $10,000, that was for rent through March.
Could you state, I'm sorry, sir, could you state that amount again? The thing went in and out.
Past due rent of $7,000, and that's for the months of December 25th through March 25th, 2025.
Yes, sir.
Okay, so I just want to make sure that you're aware of that. I understand that you're the agent, but so he hasn't paid rent, at least according to the complaint, since then, and you guys have not received any monies since December, or since November at all, or at least in some.
That's correct, Your Honor. Not that I'm aware of.
Okay. All right. Well, just hold tight. Let me speak to Mr. Stevenson. So, Mr.
Yes, sir.
Stevenson,
What's going on?
when did the initial lease get signed? You recall?
Yes, sir. It was signed probably in 2019 or 2020.
Okay. When's the last time you signed a lease?
The last lease I signed was probably in 2022. Okay. I would like to say that I'm perfectly fine with answering all your questions, Judge. Nothing. I've found a lot of evidence in this case showing that they have not done their due diligence whatsoever in this proceeding, which you've already recognized to a degree with their misnumbering of their own numbers. But I don't. I'm challenging the jurisdiction of the court. I don't believe this belongs in this court. I reserve all my rights, and I do not consent to administrate the process.
This case does not involve federal authority, so no Article 3 court has any role or oversight here. The matter properly belongs in state court and is being handled at the correct level. Jurisdiction has already been established through the facts laid out in the complaint. Personal consent is not required for the court to proceed. Rent has not been paid for 18 months, which is clearly documented. The property owners have exercised their legal right to regain possession. The court will move forward based on evidence and law rather than objections that have no
with due process under law, because I have a lot of evidence showing that I did my due process and did not receive that from them. Basically, that $7,000. He's saying that they just submitted a letter to you guys saying that $65,000 is owed. And saying
I haven't seen that ledger.
But
so
he just said it in mediation. I'm not assuming.
So just hold tight.
Yes, sir. I'm just saying I got a lot of stuff, and it's a real case.
And then we, if need be, I can get into all of that, because right now,
yes, sir.
One, what you discussed in mediation, I'm not aware of, right?
Yes, sir.
So I all of that. That's why I like to ask my questions. And
yes,
then
sir. I just wanted to make sure I got on record that I do challenge that we should even be in this court.
And I would say, if that's the case, did you file a?
I will.
But you haven't. So you have not sought to have the case removed to federal court, have you?
Not the federal yet. I was trying to get it removed just to Superior.
Okay. And under what basis?
Under the basis of equity. This is a rent-to-own case. This is not a normal tenant landlord situation.
I would pause you, because I'm very familiar with that. And if it's a rent-to-own situation, those generally are still considered contracts. You may have a lease, otherwise. And so, just before we get into that,
okay,
because I've been doing this a little while. So,
I'm with you.
All right. So tell me, is rent $1,750?
Your Honor, I'm not aware of what the rent is currently.
Well, you told me that you signed a contract back in 2020.
The contract that I signed, the rent was not. If you review.
Oh, how much is it? How much is
the rent that I signed at the time? The contract was $1,450.
Okay, $1,450.
It was $1,450.
Just getting information.
Yes, sir. Okay. I'm with you.
Did you submit your last contract online? Did you submit it as part of your evidence?
The contract, no, neither one of us submitted the last contract signed. I can't produce it, but I did not submit the last.
So hold on. Let me do my job. Okay.
Oh, my bad.
So you're saying the last rent is $1,450. Was there a late fee associated with that $1,450?
I believe so.
Okay. And let's just say for giggles, because we only gonna give him 10%, there was $145, right? So tell me this. When is the last time you paid rent? Or anybody on your behalf?
I believe the last time that I paid rent would have been in the year of 2023, December of 2023 or so.
From December 2023 through June 2025, there has been no rent paid on this property. That is a long period of non-payment with no dispute about the timeline. At this stage, the situation has moved.
Okay. And so, just to kind of get some clarity, December of 2023, that means all of 2024. And now we're moving into 4 full months of 25. And then if I were to give a writ, right, you would have 7 days. I understand you saying you ain't got no jurisdiction, all that stuff. I just want to understand what I'm working with. So it essentially would have been 16 months plus 13 days. Now, that's not what they're asking for.
Correct.
But you're saying you haven't paid rent at least for about 16 months.
Correct.
Okay. And is there any basis of why you've not paid rent for 16 months?
Yes, sir. They have some funny accounting. And so I submitted in accordance with UCC and all other statutes and legal statutes. I submitted a request for accounting, a full request for accounting, which I have a right to do. I submitted it under certified mail to the registered agent's address per the law. The registered agent received the first letter. I have all received, everything's in front of you in the submitted stuff. I submitted a document requesting a formal request, asking and saying that I would pay whatever was needed as long as they produced actual documents, especially because they're filed under a trust. So they're supposed to complete certain things as a part of their business model of how he's even running his business. And so I asked for that to be produced, and I would pay. The first one came to them, they received it, then they closed it back up, taped it up, and they rejected it. I sent 2 more. One of them I sent notarized, which is the big envelopes you have. I sent the notarized copy. You also have a copy of what I asked and requested from them under the law. They ignored them 3 times. Then didn't ask for any rent for a year, Your Honor. And then when they did send me a notice to pay or quit, it was for $6,500, and now the $7,000, which is what you're looking at.
Okay, so let me pause. Let me pause because there's a couple things going on, and I don't know. You may not like what I'm thinking, but I'm just. You got 16 months past.
No, I wasn't at the time, Your Honor. I wasn't at the time.
I got it, but now you 16 months past.
Yes, now.
They're asking for 7. When did they demand 65?
Today.
Okay, so did you get any notices about this hearing, or about this action before?
No, he said all this
it was filed against you?
He submitted new documentation today in mediation. He said he submitted it today and that y'all received it in court for $65,000. I have no knowledge of that.
Okay, well, pause. This is an important thing. It's important. I saw your defenses that you raised. Mr. Brown, can you tell me when or send Mr. Stevenson a demand of possession?
When was it sent to him? There was a pay or quit notice, and I do not know at that when that was sent to him, but I might be able to find it in the file.
That's going to be huge.
Okay. I believe the pay or quit was very recent. I believe it was last month.
Last month when?
Let me see. I have this pay or quit. Oh, here's one from July of 2022. Here's one from July from 2021.
Let me see something from 25.
All right.
I have it, John. It's 3/15/2025.
3/15/2025.
Yes.
Okay. And what did it say?
It said undisconnected rental rate $1,750. Rent from January to March $5,250. Additional daily rent $10 per day at 92 days $920. Recovery $75. Existing unpaid balance $321. Total due 3/20/25 6566.00.
Okay, so how much is that? Tell me how much they're saying is due.
$6,566, Your Honor.
Okay, and then when you got that, what did you do?
I filed with them a failure to contract, a no contract notice, and I refiled with them the notice I filed for them to give me proper accounting with the certified notary from the year before that I tried to file to them that they rejected because he's using a PO box as a registered.
Are you alleging that you paid too much money to them?
I'm alleging that I have equity in this home and that the stated amount that they are saying. The stated.
Even if we assume every statement you made is accurate, the outcome would remain the same. In a rent-to-own agreement, timely payments are a core requirement. Most of these contracts clearly state that any default allows the owner to terminate the agreement. Once that happens, any prior equity tied to the arrangement is forfeited. Failure to meet payment obligations cancels the benefits of the contract. As a result, any value previously built through payments no longer.
All right, equity in this home. Neither one of you have submitted a contract. So tell me what.
I didn't file a complaint.
Well, but you're having a defense that you have equity and rights in this property, right? So it's your responsibility. So listen, it's your responsibility to put up all the necessary defenses to support you, right? And so what I'm saying is, you're saying you have a special kind of lease. So tell me what parts of your lease, since I don't have the lease here with me, justifies it. Well, hold on. Okay, I guess Mr. Brown was going to answer that. Mr. Brown,
I thought you was okay.
Okay. Do you?
I'm fine. I'm quiet. I ain't said nothing, man. I'm good. I thought you was talking to me, so I thought I was.
And I'm sorry, but you were just going. I just want to know what part of the contract. How do you have it? You have a lease to own? Is that what you have?
It is a rent to own. It is a rent to own where you're only supposed to be in it 3 years, and then you either basically leave or you're in an ownership position. I have to do my own maintenance. There's no. That's not me. That's coming out from my side. There's no. They don't come do a bunch of maintenance. I have to fix my own back porch. I got to do. You know what I'm saying? So. What I was asking for a year ago when they came to me saying, hey, you owe some money, I felt like the accounting was off. And so I asked to see the accountant. They refused to show the accountant. That's it.
All right. Mr. Brown.
Yes, sir.
A lease to own agreement?
I'm just looking back. It would have been long expired if there was one. I'm just looking back right now because we do have a rent-to-own opportunity, and we do help deserving families end up with home ownership regardless of credit or financial background. So we work that into our program, and we give people up to 3 years to buy. And so when he signed in 2019, that would have been expired by now. And I'm just looking back to see if he even did that.
I'm not going to further delay this. This is what I'm going to do. I'll be honest with you, Mr. Stevenson. The initial facts, and because of the history I have with these cases, I would argue that they would be entitled to a writ. Particularly the amount that they're seeking is a lot less than what you would normally be paid but guess what I don't have? I don't have a contract. And you make an argument that you may very well be entitled, but I don't have it. And depending upon the language of that contract will really make a determination of how I proceed. And so I'm going to reset it for in person. I don't necessarily believe that there's a basis for it to be in superior court. Those issues based on the contract may reveal that that's not necessary, particularly if you're not alleging that you've paid all this time or have submitted to them a opportunity to purchase and they didn't accept it. That's a different. But just saying that you have a lease to own, but then you've defaulted on it and you're very well entitled somehow to some type of equity. You might be entitled in a separate action and maybe some of the improvements that you've made, but that may not prevent them from being able to get you evicted. And that's a fact.
Your Honor, can I ask a question?
Sure.
Okay, so the fact that I still have a UCC claim, 100%, they did not respond to my request I have a right to accounting. They blocked it. What about the fact
that may not prevent me from dealing with possession? See, I think you misunderstand.
Oh no, I'm not saying. I get that. That's what this is dispossessory court. I get that's why I asked to have it removed to a higher court. What I'm saying is, you need
to file that stuff.
Well, I will file it because I don't want to be put through this administrative process, which just basically is, and it's just kind of a quick kind of will and deal thing. And he's got legitimate. I have legitimate things that I'm saying. I asked for accounting for debt, and then now for them to submit a debt of $65,000. So what you're telling me is we're going to come to meet you, and we're just going to discuss the $6,500 and not the $63,000 that they're trying to put on the ledger now.
Well, I'm going to be honest with you. If you ain't paid rent in a year and a half, that wouldn't necessarily sound like that's not reasonable.
No, but under the law, though, I have a right to nullify.
It is not how the law operates in this situation. Entering a rent-to-own agreement creates clear payment obligations. Failing to make payments for an extended period does not cancel those duties. There is no legal method to simply declare the debt void without meeting the terms of the contract. Agreements remain.
I'm going to reset the case. You're not even going to have to worry about an appeal because I'm not going to do an order today. I'm going to reset the case, and someone's going to submit to me the copy of the contract, and then we can take a look.
Your
Mr.
Honor,
Brown.
I did submit the contract. If you'll look at the email that we did send both the contract and the extension.
Clark, can I? It's not in my file, or maybe it's in documents and not in exhibits. Hold tight. I see that. All right.
It
I
was
don't
sent
see-
to Dispossessory, seat court 2. Let me see here, so I can be correct. Dispossessory CT2. I can't see the full extension of the.
Clerk, do you have an email from Mr. Brown?
I'm looking. Sorry.
Thank you. It would have been from Judy Weaver, my assistant.
And Mr. Stevenson, just so you're aware, if you're alleging federal matters, that isn't necessarily a Superior Court issue. That's a federal court issue. So having it removed or transferred to Superior Court still wouldn't be the appropriate place. Just to
it may be a federal thing. I'm just saying that I asked for the accounting of all of this so that I could pay and do my due diligence. They failed to do that, and then didn't request any money for a year, and then they just showed up.
And Mr. Stevenson, while we're waiting to see whether or not that's the case, what due diligence were you trying to exercise in a rental agreement? Was it a situation where they weren't?
It was a situation where I did not agree with what they were saying was owed by me at the time. They were saying I owed more money than I agreed with. So I filed a form saying, show me the full, because we've been in business, like he brought up, during COVID. And just for the record, I just lost my mother on Easter, right? So I'm
sorry about that, brother.
I'm just saying, because he was mentioning, he mentioned that the clerk who filed all this stuff improperly has been in and out of the hospital. I've been through with breast cancer for the last 3 years. What I'm saying is my due diligence was still done properly, and theirs was not. And I feel like the court has to honor the fact that you have to do business the proper way. And so that's my stance, is that I asked for them to do business properly. They did not do it properly. They did not say anything. They left me alone for a year. No mail, no correspondence, no nothing. And then show back up and requested $6,500 for the new year, not 2024.
All right, hold. So the original one, this is 2019. It's a standard real estate rental agreement. I'm gonna share this thing with you.
No, I know it's a lot in there. It's so much to the bottom where they get into the rent to own stuff. You come to classes.
Hold up. I got you. Hold tight. All right. So at this time, can you see what I see?
Yes, sir.
All right. So I'm gonna scroll on down. You tell me what section is the rent to own.
Okay.
And either one of you guys go ahead and jump in and tell me.
No part of that agreement refers to rent to own.
This isn't the full.
Okay.
This isn't This doesn't have anything mentioned about the other part of the program that they have, which is the path to home ownership. That's it also in the agreements.
All right. So there's a path home ownership.
Path to home ownership is what it's called. It's not listed. They're not showing that in that document they submitted.
Direct path to owning a home is meeting your financial obligations on time. Consistent rent payments build stability and credibility. Ignoring those duties.
All right. Let's see another one. And then here goes the one for 2022.
Yes, sir.
Hold tight. All right. And this one says extension of standard real estate rental agreement. That's what it says. It says 1750 in 2022. Looks like these are your signatures here electronically.
Yes, sir, but this is not their full program, and he can tell you that.
All right, well, Mr. Brown, tell me all about
He told you that the program lasted for 3 years. He's saying he told you the program is a 3-year program. That's it. That's the truth. You can look it up online and look their system up.
Listen, Mr. Stevenson, stop. I'm not against you, but I'm going to find it out.
I don't think you are. I'm just telling you.
So, Mr. Brown, tell me, he's saying that there's another part of this agreement that's not there, that's different from this. So, is that the case?
When we do enter into an option to purchase, it is a 3-year term, and that would have begun in 2019. That would have expired in 2022. It was not extended.
Well, I don't know that. because you have a 2022 extension of standard real estate agreement.
There is no need to search through personal files because the judge already has the rental agreement displayed. The document is visible to the court and confirms the key terms of the lease. For privacy, the agreement is partially obscured from public view. Even so, the section showing the required monthly rent is clearly presented. The amount is listed as $1,750 per month. With that information established, the court is ready to move forward. The next step is the judge issuing a ruling based on the agreement and payment.